court, please?
This court is now in session.
May be seated. Okay, this is our second case on this Wednesday, September the 18th. This case is James Crite versus Commonwealth. Ms. Schmidt, you'll have 13 minutes and you'll reserve 2, is that correct? And Ms. Hedges, you're going to go 15 straight through, is that correct? All right, are there any preliminary matters we need to address before we get started? All right, Ms. Schmidt, you're up.
May it please the court, counsel. The very core of the Fourth Amendment is the right to be free from unreasonable governmental intrusion into our homes. Our homes is where our expectation of privacy is the strongest. Yet most of us acquire our homes from renting or from having to have a mortgage. We have a relationship with someone that has a property interest in our home. But that relationship, especially under these facts, does not give the police the right to enter and search our homes and seize our property because a landlord asked them to.
I just want to make sure that I'm clear on the facts here, because I think they're very important in every case, but particularly here. Initially, I was under the understanding that there was a phone call from the tenant to the police officers, come walk with me through here because there's an apparent danger, or I feel at risk going through here. But in this case, and please correct me if I'm wrong, there was a 2-day period from the first contact by police, by the landlord to the dispatcher. And at that time, was it communicated that I've seen a gun and I think he's a felon? And then 2 days later, the inspection took place. Is that correct?
So what happened was, and the timing on the call from my client's brother is a little sketchy, but he called and left a voice message. Then on July the 9th, he actually talked to the landlord and said, my brother, take him to the hospital, he's off his medication, he's schizophrenic. He's also a veteran, and that's part of why he has these issues. But they said, and there's damage in the property. There's damage in there. So the landlord sends another person from the management company over to assess the apartment because they believe he's not there. She sees the damage.
But the brother asks for the damage to be repaired.
He has absolutely no authority to do that. I know that's a human thing, but he does not have a relationship. He does not have a lease. It would be no different if a neighbor did it or a person off the street that overheard them saying, oh, the apartment's very hot and there's no electricity. He can't demand that the landlord do anything. The landlord could have asked him, can I speak to your brother? Could have tried to contact the brother or William. They had their contact information. But the brother could not give consent for the landlord to go in. And I'm going to answer your question about the facts, but then I'm going to argue it doesn't really matter. It doesn't matter whether the landlord had access or not. The cases all hold that even if the landlord has the right to access, that does not mean they can let the police in. But so she sees this on July the 9th. She takes pictures. She says, the breaker is off, it's flipped, it's cool to the touch, there's no fire, there's no smoke. She does not alert the other people in the fourplex, which is part of the reason they end up calling the police is for their safety. She doesn't call 911 because she says there's no reason to. They don't call the police or the fire department. She goes back and reports. The next morning, the landlord calls an electrician to meet her over here. And then when they get that set up, she calls the police department because she is afraid and she wants them to come for her safety and look in the apartment. And she sets out why she's afraid.
Did she indicate to them at that time that I think he's a felon and that there's been a gun seen here that would have maybe alerted them to obtain a warrant?
They do know that before they get there. They know it from Central Dispatch, I think, relays all this. The testimony is at least one of the officers before they got there had reason to believe he was a felon. So at that point, you're right. They could have tried to get a warrant, but they didn't. He also had a capious warrant, and they were very honest. They said, we did not go over there to serve that warrant. I'd never heard that term either. I think it's for a failure to pay a fine. I don't think it's even an FTA. So they were unconcerned with the capious warrant.
That was going to be my question. What was the underlying charge on the warrant? Did it make him a fugitive? Nobody knows the charge on the warrant?
Nobody knows, and obviously the government has the burden, and they did not produce any evidence about that. All we know is that the police officers specifically said, we're not going over there to serve that warrant.
Was it reasonable, and you probably aren't finished with where you're going, so I want you to get back to it, but I think her name was Robertson, maybe the agent of the landlord, was it reasonable for her, based on what she had observed and what she knew, to be afraid for her own safety and to contact law enforcement to at least assist her with going back to the premises?
Well,
and does that even matter? You're probably going to say it doesn't, but
it doesn't, but let's unpack it a little bit, because the facts of what happened gave her options. One, she can call the police, and as the court said in Coniglia versus Storm, the police, just like any of us, can go up and knock on a door and ask. And they did that. The police went in. They were told they wanted to assess whether anybody was in the apartment. They walk up. They knock. They knock several times. They announce. They testified at the suppression hearing. They didn't hear anybody. They didn't hear shuffling. They didn't think anybody was there. It was at that point, and the trial court found this, that they told her, we don't have any reason to go in this home. They clearly did not have a reasonable belief that they needed to go in the home. They also testified, we didn't have exigent circumstances, but again, it's a human moment. What happened was the landlord basically begged them, would you please go in and check? The landlord, again, could have tried to contact the tenant or the tenant's brother to at least find out where the tenant was, because that was the basis of her fear. Really, I don't know where he is, and I'm concerned about these other things. She didn't do that. In fact, if she had waited 30 minutes or had called them, they ended up back there, and she could have talked to them. But
Ms. Schmidt, just to follow up on Justice Keller's question she just asked. So she was asking, was it reasonable for the landlord to believe that maybe because of the issue with the wires or for other reasons that there was an emergency or there was danger, that this tenant was schizophrenic? Just to extend that question out, under Commonwealth v. Norse in 2005, this court said, so we're looking at a Fourth Amendment case, so we're looking at government action. So we first have the landlord lady and what she thought, but then law enforcement and when they walk in. So it must be adjudged against, and this case says, an objective standard. Would the facts available to the officer at the moment of the warrant make a reasonable person caution in the belief that the consenting party had authority over the premises? So you're giving us reasons whether or not it's an emergency. But we've got a landlord calling law enforcement into the situation. In other words, they didn't just show up.
Right.
It wasn't their own investigation. They weren't going to serve a warrant. So they are called there by someone who says, I'm a landlord of this multi-tenant structure, and we think that there may be an electrical problem. I understand you said the box was cool, but here we're putting ourselves, what did the law enforcement think, and was their belief reasonable, is what the court needs to look for under Norse. If they're told those things, this person's schizophrenic, it's a multi-tenant building and there are electrical wires, none of us want to see anybody go down in an electrical fire. On what basis should we find that that wasn't reasonable?
well, there's two things the officers have to look at, and I think they've gotten kind of mixed up in the case. One is, do they have a reasonable belief that somebody is in the apartment? If not, they don't. There's no reason to be afraid. I mean, that's really the bottom line, whether there's an emergency or not.
What about the wire situation, whether somebody's there or not? What about the wires?
Well, that they were not called there to help fix the emergency, and the landlord, if the landlord had believed there was an emergency, we're not saying, we disagree there was, but if there was, the landlord can go in, we're not saying that, but she just doesn't get the police as a private individual to clear the place for her when they don't have a reasonable belief. But let me also talk about the test from Norris that you just read.
Counselor, just because somebody doesn't answer the door doesn't necessarily mean there's no one in there. And, you know, that's the situation they were in. Nobody was answering the door.
Well, they can't just suppose based on no evidence that somebody is. I mean, it's kind of, this is not a protective sweep, but if they testified to that in a protective sweep, this court would throw it out. We're just assuming somebody's in there. But let me go back to this, because look at what happened in Norris. This court actually decided Norris because when they knocked on the door, a girlfriend answered. Somebody with apparent authority to do it. It is a complete red herring, and there are no cases to support it, that the police can just assume a landlord, based on nothing else than they have a key, has apparent or actual authority to let them enter and search. That's why this is a case of first impression. I think they cited a case, but what made that case different was the landlord had told them.
Your premise is just the landlord based on nothing else. And I think the court would agree with you. Generally, landlords don't just willy-nilly let people in. It was landlord plus story of other things going on in that apartment. In the example you just gave, you said just landlord letting police in. It's landlord plus story.
Well,
I would say here.
but that story, especially once they assess the situation, does not give them her authority to let them in. Again, she could have contacted either my client or his brother to gain more information. But let me get to the real thing that decides this case. And I think the Court of Appeal erred, and the trial court did, in giving short shrift to Coniglia versus Storm and what the United States Supreme Court held in 2021. In that case, they were asked by the First Circuit to find a standalone exception to the warrant requirement where the police are asked to do something in a non-criminal capacity for the public. What happened was and the case that this started with was Katie versus Dombrowski, where the court recognized that sometimes the police are asked to do things like investigate people that are broken down on the road, help people broken down the road, help with traffic after accidents, things like that. They came across a car and they impounded it, and then, what they did was they seized the gun that was inside the car. What the First Circuit asked the U.S. Supreme Court to do in Coniglia was extend that to a home. And what happened in Coniglia, which is very similar to this case, is a husband and wife were having a fight. The husband pulls out a gun, puts it on the table, and said, well, you might as well just shoot me now. The wife gets mad, spends the night somewhere else. Then she calls the next morning, and she can't get a hold of him. And she is afraid because he has mental illness problems. He's got these guns. She calls the police. They are not investigating a crime. She is calling, basically asking, can you help me find out if my husband's okay? They go, he's on the porch. He's not in his house. They assess him. He says, I'm fine. I'm not going to hurt myself. They disagree. They think he needs to go in an ambulance. They get him in the ambulance because they promise him and the wife that they won't seize his guns. Then, as soon as he's gone, they go in and they seize his guns. And there's no red flag law or anything like that would allow for this. The Supreme Court could not have been more clear that we have a few very specific, well-defined exceptions to the warrant requirement when it comes to a home. And this doesn't meet it. The police, when they're doing these non-criminal things for the public, again, they might be a good service, but that does not allow, the Fourth Amendment does not allow them to do that. And so,
is there not a difference that in this case there's a lease that gives the right to the landlord to go in, and I know you disagree it's an emergency, but it does say they can go in the event of an emergency, and it says landlord or landlord's agent. So how come the police in this limited circumstance is not the effective landlord's agent to go in and make sure that there's no danger to the people who are then going to go in at the behest of the landlord?
Well, one, they're not dealing with the emergency. They're,
Well, I understand that, but I kind of took that out. I understand you disagree with that.
well, if you look at Norris and Matlock versus United States, which this court discussed, their test for whether they had authority to do this was, I mean, it doesn't matter whether the landlord had legal authority to enter or control the residence or not. The lease didn't really say this could include me allowing the police to go in. That's governmental action. I don't think the average person, without that being in the lease specifically, would believe that your right to privacy could be violated in that way. Perhaps you could write a lease that said that.
I'm talking about this lease. I'm talking about
Right.
this lease.
I don't think that lease includes her being able to transfer her power as because she has a property interest, into letting the government, giving the government authority to go in and search and seize his property.
So the lease clearly gives the landlord or the landlord's agent, Robertson, the authority to enter the dwelling in case of an emergency without consent of the tenant. But your argument is the lease notwithstanding, there's no agency or anything else that would transfer from Robertson or the landlord to law enforcement.
That is correct. I think these are pretty standard lease provisions. They mimic, there's a uniform residential landlord and tenant statute that gets a little murky because nobody ever said whether Owensboro had adopted that, but they're basically very similar provisions. I think these are pretty standard lease provisions. So yes, that is my
Well,
argument
actually, I did
because,
look that up, and they have not adopted it.
okay,
So
thank you.
So red flag, red herring, that provision
Yes.
does not apply to this case.
Thank you. But if that were the case, if you could just find that the landlord could designate the police, one, I believe that totally violates Calignia versus Storm, but they acted as police. They seized his property, they arrested him, they charged him with a crime. They were not there just for benign purposes for the landlord, and it would gut the Fourth Amendment to find that. We have all these, this is a case of first impression, I think, because so few of these cases arise without some extra factor where a landlord just lets the police in and they go in with no exception. So it would gut the Fourth Amendment to allow landlords to just do that, say, oh, now you're my agent, you can go in.
As all these Fourth Amendment cases, though, it really turns on the specific facts. And there is a scenario where Robertson could have gone in and seen, I'm going to say, more compelling things that were a threat to public safety and health, or the safety and health of the other tenants, something that was more attuned to exigent circumstances, and notified the police. And then I don't even think this agency issue needs to be determined. Then it's just any other tip to law enforcement that exigent circumstances exist, and therefore there's probable cause to go in and without the warrant.
And that's how some of these cases end up being decided. It really becomes more, the police are notified there might be a crime. Something occurs, and then they apply whether there's an exception or not. Say she goes in and there's a ticking time bomb. Nobody says she could not call the police and say, I mean, there's an emergency aid exception. There are recognized delineated exceptions, and as long as there are, then the police can go in and do that. Say they not.
But this trial judge seemed to be convinced that there was emergent or exigent circumstances.
Not exigent circumstances.
Emergent.
He thought there was emergency to allow the landlord to go in, not for the police to go in. He was pretty clear about that. He thought she had reasons to be afraid. But then the third finding was that this wasn't a criminal investigation. But all the cases that say that have really been now discredited by the holding in Calignia versus Storm, because they have just done away with that. And it never made sense to me because they are still the police and they are acting as the police. And, they seized his gun and arrested him.
But isn't Calignia still a little different as we go back to these facts, and that they were checking on the welfare of someone versus here, we can argue whether or not the facts presented here are emergent, but it's not just a welfare check to see if somebody's alive or around. It is, we're going in because there may be an electrical problem that could be dangerous, and the landlord is aware of a weapon and a history of schizophrenia.
The police did not go in there to see if there was an electrical problem. That was not.
Well,
why
they
went in.
accompanied someone who
Right.
needed to safely go in to address that problem.
That was not why they were there. And it kind of, in essence, they were going in as a welfare check for her to make sure. And say they knocked on the door and they heard mumbling, or they heard glass breaking, or they heard something else, and they knew he was schizophrenic and off his meds. They probably could have gone in at that point under the emergency aid exception. I mean, these cases are all very fact specific. But again, even aside from Calignia, but I think that if you read that case, I know that it talks about those facts, but it talks in broad terms about you're helping the public in a non-criminal setting and what you can and can't do. And I think that applies, and this court should adopt that, because that just is the United States Supreme Court, the interpretation of the Fourth Amendment. But even on the fact.
We're going to let Ms. Hedges have her say so, and you've reserved your 2 minutes.
Can I ask one quick question?
Sure.
When the police were in the apartment, did they seize the gun that they found? Did they take it in possession?
They did eventually seize it. It was a little unclear whether they went out and came back and seized it, but yes, they did seize the gun.
But not during their protective sweep?
Again, it was unclear. They were both a little confused about who did what, because they said we kind of worked together. But they did seize it. They saw it in the sweep, and then they seized it. They did see it when they walked through the first time. Thank you.
May it please the court, Elizabeth Hedges on behalf of the Commonwealth. Yes,
Ask you a question before you even begin,
Absolutely.
but maybe you'll find it helpful.
absolutely.
I went back quickly to look at the trial court's order and judgment, which was thorough. And I don't think the trial court dealt with Coniglia. I was looking at the dates, and I think it was, okay. So, can you address that? Because they rely on plain, people be plain. And, I mean, I really need to square with how the trial court saw these facts in applying the law.
Yes, Your Honor. So this is not a Coniglia case. And in Coniglia, actually, the court said there was no consent and there was no emergency. And so the holding of Coniglia is premised on those two assumptions. This is a case about consent, and it's consent based on an emergency clause in a lease. So the Coniglia is just a distraction. This is not a community caretaking case. This is not an exigency case to preserve evidence. It's none of those things. The reason the landlord's agent, Ms. Robertson, had the right to enter was because Mr. Crite, in his lease, gave the landlord the right to enter in an emergency. So the trial court correctly concluded first, and he does this actually, as you noted, it's a thorough opinion, he does this very well. He first finds that there was an emergency, and then he finds it was also reasonable for Ms. Robertson in that situation to let the police come in. Now, why is that important? So there's two things going on here. There's two ways that this court could uphold the decision. There's an apparent authority, which I think your questions and Justice Bisseck's questions were getting to, and then there's an actual authority. And under the actual authority, what we're really centered on is the language in the lease, and was this an emergency? And then under the apparent authority, we're looking at cases like Norse and the U.S. Supreme Court decision in Illinois versus Rodriguez, and we're looking at would a reasonable officer have believed that the landlord's agent had the right. And so I think the question about Ms. Robertson's reasonableness in wanting the police there goes to the same questions that we'd be asking about whether the police reasonably thought that they could be there, and that is to keep her safe. And Your Honor mentioned Plain, and Plain is actually a good place to start here because that case looked a lot like this one. And I do want to circle back and tie this into the facts of the case and Justice Nichols' question about the timeline here. So in Plain, as in this case, The landlord didn't enter the apartment with the police until the next day. And the court said that was okay. And this also shows us, as does the lease, which I'll talk about in a second, that emergency under the lease is not limited to a 911 call situation. How do we know that? Okay, so look at the facts of Plain. The facts there, the reason that the landlord entered were because the guy had left his lights on, and the landlord thought, he's afraid of fire, but there was no evidence of a fire, and the guy had left his cats in the
He was
apartment.
afraid he left his stove on as well, is what.
Yes, exactly. So he was worried about electrical fire, calls the police, and really the only reason he wanted the police to come with him was because he was afraid of getting accused by the tenant of stealing something. So that was even less of an emergency. But then let's talk about the lease in this case. So the lease in this case, it has this provision: the landlord or landlord's agent may enter the dwelling unit without consent of the tenant in case of emergency. That provision is in a section of the lease that talks about the landlord's right to enter the dwelling unit in order to inspect the premises and make necessary or agreed repairs. We also know, previous provision in the lease, the landlord agrees to make repairs and do what is necessary to keep the premises in a fit and habitable condition. So the landlord not only has the right to enter an emergency, the landlord has the obligation to maintain this place in a reasonable condition, in a habitable condition. And let's just talk about the facts here. So just to clarify, one of Justice Nichols' first questions, what happened? What happened is this: trial court made a finding, and this is supported by substantial evidence, that James Crite's brother William made his call on the emergency notification system on July 9th. Okay. Century, which is the property manager, their employees get that call on July 9th. Ms. Robertson, who's the property manager, sends Ms. Reynolds, who's the leasing agent, over that same afternoon to Mr. Crite's apartment to look around. Please check on this. So Ms. Reynolds goes over there. She sees that the apartment is as described, and what Mr. Crite's brother had described was that there was wires torn out of walls, the AC wasn't working, the electricity wasn't working. Mr. Crite was off his medication, and so his brother was getting him out of there. So Ms. Reynolds goes and she confirms all that. She also sees what she thinks is a gun on a table in the apartment. Turns out later it's a BB gun.
She goes inside the apartment.
She does go inside, right. She goes inside. She said she did a very quick walkthrough. I think she testified at one point it was less than 5 minutes. And the trial court found this is on July 9th. She comes out of the apartment. She's kind of scared because she saw what she thought was a gun. She calls Ms. Robertson, says, this is the situation. Ms. Robertson says, okay, I'll take care of it. Next day, she calls an electrician. And then as soon as she's got the electrician lined up, she calls over to the central dispatch. And at TR-73 is the CAD report for that call. And she says, I've got a tenant who is off his medication, schizophrenia medication. He's torn wires out of walls. I need to go over there with an electrician, but I don't feel safe because I don't know where he is. Because by that point, she had learned that he hadn't been admitted to the hospital, which was what had been supposed to happen. So she doesn't know where he is. She's got to go over there and get it checked out, and she wants the police there to help keep her safe. Okay, why does all this matter? First of all, it matters because clearly there's an emergency. And as I mentioned, emergency includes a maintenance emergency. And so just like in Plain, there wasn't really a long delay here. All of this took place within about 24 hours. And the other point I would make on the timing here, if this court has any concerns about Ms. Robertson going over the next day, first point, this actually did take place pretty fast. So if you consider like learning about the condition of the apartment on the afternoon and then making it over there with an electrician by the next day, that's actually pretty fast in landlord-tenant world, especially considering that this wasn't Ms. Robertson's only property. So she was juggling a lot of stuff, and she still managed to make it over within the next day. She testified she thought it was an emergency. We know that Mr. Crite's brother used the emergency call notification system, so he thought it was an emergency. And so that goes to actual authority under the lease, and it's a straightforward consent case. However, if this court doesn't want to make a firm holding that there was, in fact, an emergency, then we get into the questions that Justice Keller and Justice Bissek were asking about kind of reasonableness of the facts and what the police might have thought based on what they perceived. And so the question under Illinois versus Rodriguez and this court's cases like Norse is whether the facts as they were known to the officers would have warranted a man of reasonable caution in believing that the landlord had the right to consent to his entry. And I want to go back to something that counsel for the other side said. talking about this reasonableness here, and I think at one point there was a discussion about, does it actually matter whether she was reasonably afraid? And it does matter, because if she is reasonably afraid and that's why she calls the police and they're not there for a law enforcement purpose, that goes to, there's no pretext, they're not there to find evidence, and it goes to the reasonableness of them thinking that she has the right to consent to their entry. And we can look at the background. So there was discussion about the statute, the landlord-tenant statute, and it's correct, as Justice Van Meter noted, that Chief Justice Van Meter noted that that hasn't been adopted in this county, but it does form part of the backdrop of what our societal expectations are for when a landlord gets to enter the apartment, especially because it exactly matches the wording in the lease here in terms of an emergency.
Can I ask you a question?
Yes.
When the landlord went through to check things out before she went to the expense to call the electrician, did she see the wires pulled out of the box?
Yes, Your Honor.
Okay, thank you.
So Ms. Reynolds, who went there on the afternoon of July 9th, she saw that there were wires torn out and so forth. And so then she called Ms. Robertson and told her all of that, and that's why Ms. Robertson called the electrician. And I would point out here, it's slipping my mind who asked this question or who made this point, but the risk here was the risk of electrical fire. And so there's some discussion in the briefs is like, well, you know, the breaker was shut off and maybe there wouldn't have been a fire, but the trial court made a finding, and this is supported by substantial evidence, that there was a risk and that it would have been difficult to determine the extent of the risk, and so that's why it was reasonable to get an electrician out there. So we get the electrician out there, and that's why Ms. Robertson wants the police to go with her. So just to clarify something really quickly, so to Justice Thompson's question about the habeas warrant and whether Mr. Crite was a fugitive, I think, I wouldn't use the word fugitive, but I think a habeas warrant is issued generally when someone has failed to show up to court, and it's basically, they're supposed to basically be brought to court because they failed to appear. So I don't know why he was supposed to have been in court at that point in time, but that's basically all the warrant was, and that is why he was eventually arrested in the parking lot later. So again, and this is important because as the officers testified, they didn't go to the apartment to execute the warrant. They didn't go into the apartment to look for evidence of a crime. They told Ms. Robertson, we don't have a reason to go in there. And she said, well, will you please go in there because I don't feel safe. And that's when they went in. And if you look at a case like Plain.
This was the question asked Ms. Smith. I mean, the lease gives the landlord or the landlord's agent, and I mean, the electrician is the landlord's agent, so why wouldn't the police in this limited capacity be the agent of the landlord to go in and just check?
Right, Your Honor. So I think that is a way the court could go on this. I don't think you need to get that far. I don't think you need to find that the police are the agent. And the reason is the cases don't even require that. So if you look at the Farinacci case, which is a Sixth Circuit decision that we cite in our brief, it's unpublished, but it's very persuasive. That's a case where there was a mortgage provision saying the bank, which is the mortgagee, I guess, has the right to go into the apartment to protect its interests, basically. And what happened there was someone stopped living in the apartment and she left her cats there. The bank's servicing agent basically calls the city and says, would you please go get the cats out? And so the big fight in the Court of Appeals was over whether the bank's agent had the right under the mortgage to ask the city to go in there. And the plaintiff said, well, I have a Fourth Amendment claim because even if you have the right to go in as the person who holds the mortgage, you don't have the right to let the government go in. And the court rejected that. And the court rejected that because they looked at the lease and they said, lease says you can do what's necessary to protect your interests in the property, and in this case, what was necessary to get the city to go in there. So they didn't even need to make that finding that there was this agency relationship with the government. And I think, again, that's one way this court could go, but I think it's actually even simpler than that. The agent is obviously Ms. Robertson, and then as Your Honor pointed out, the electrician is the agent of Ms. Robertson because she's hired him. And then she asked the police just to come because she has the right to do that. She has the right to consent under the lease. And what all of the apparent authority cases ask is whether someone has apparently the right to consent and whether the officers would be reasonably justified in believing that. And so if you look at a case like Norse, The court didn't even need to reach whether the landlord had authority because they found that the defendant's, I think it was his ex-girlfriend, had apparent authority because she appeared to be living at the apartment. And so the reason I'm going on and on about this is because I think the way Your Honor framed the question is one way to go, but I think it's even easier than that because once the landlord's agent has the right to consent to someone entering the apartment, she has the right to consent to the police entering as long as it's reasonable. And the point I would make on reasonableness is I'm not going to stand here and say that any kind of search by the police under any circumstances is reasonable. What I'm saying is this search was reasonable because the trial court found they were not there for a law enforcement investigatory purpose. And the court actually says that, summing up at the end of its opinion, it says there's 3 factors for why I think the search was permissible, and one of the factors was they weren't there for a law enforcement purpose. There's another case that we cite in our brief called Huber out of North Dakota that also kind of focuses on that lack of an investigatory intent. So that's why there's no pretext in this case. This isn't a Coniglia case, this is a consent case. The other point I just want to make is like we need to step back here, and I think this goes to Justice Keller's questions about was it reasonable for her to be afraid. We need to think about what the alternatives were. So let's imagine she doesn't call the police when she does, and again, she did so within 24 hours. Let's imagine she doesn't do that and she just waits. So now you've got a situation where there's a risk of electrical fire, no one's fixing the wires, the place is just sitting there, it's 100 degrees outside in the middle of July, and who knows what could happen. There's 3 other units in that same building. Plus, maybe Mr. Crite, she knows he's not in the hospital at that point, maybe he comes back, he's still off his medication, he hurts himself or someone else. That would be really, really bad. Another alternative is she goes over there without the police. Then she's there with an electrician who, you know, she has some kind of, obligation to like look out for his interest at that point, and she tries to go in there without the police, there could be a confrontation and maybe someone gets hurt. So she doesn't have good options at this point, and I would say that Ms. Robertson took the most reasonable option, which was to ask the police to go with her.
You just gave you mentioned 105 degrees. What time of year was this search?
It was July 10th. So it was, and Ms. Reynolds testified at the hearing, she thought it was about 100 degrees out when she had gone in on July 9th.
Okay,
So
thank you.
She said it was burning up in there. Those were her words.
Good,
So,
thank you.
yes, Justice Keller. So, I think I'm about out of time here. I would just close by saying, again, I think this court needs to think about the actual authority question in 2 steps. The first question is, well, there's really only one question, which is, does the lease give Ms. Robertson the right to enter and thereby to consent to someone else's entry in the event of an emergency? And then was this an emergency? And then we can talk about, well, was it reasonable for her to ask for the police to come? And it clearly was because of the safety concerns that we've mentioned. And then the final thing I would say is, if this court doesn't find that there was actual authority under the terms of the lease, then this court should hold that there was apparent authority because the facts as they were known to the officers made it apparent that Ms. Robertson had the right to consent to their entry. So I would ask this court to affirm. Thank you.
Thank you so
Thank
much.
you.
Ms. Smith?
First, the idea, the police themselves never relied on the fact that they thought the landlord had apparent authority or actual authority to let them in. They just said she asked, and they went in. After they had already told her, they expressed their reasonable belief is there's no reason for me to go in here. There was no discussion about this. There's no factual basis for anybody to find on this record
But doesn't that bolster the assertion that, as the trial court noted, the police were not there for any criminal investigatory purpose. They were there to provide a public safety or personal safety support, which is part of their duty as well. And because they saw what they saw in plain view, do you understand what I'm saying?
I totally understand what you're saying, but what I'm saying is, and I try to be very clear because it's important, the Fourth Amendment does not recognize that as an exception to the warrant requirement. Coniglia does apply. It wasn't decided before the trial court heard this, but under Griffiths versus Kentucky, it was decided while it was on direct appeal, and that was the broad holding in that case. When the police are going somewhere for a non-criminal reason, Can they enter, can they search, can they seize? Because they're trying to help somebody out. And they can't. The court rejected that. We have to stick with what.
But isn't there a difference that in that case, there's no one to consent to give them the right to enter that house in Caligula? But in this case, there is someone to consent, being the landlord.
There isn't, because she couldn't consent to this. This is not consent. We're talking about consent. But consent would have been from James. This is really permission
No,
to enter.
James signed the lease, giving the landlord the right to, I know you say there's not an emergency, but let's get over that. And if there is an emergency, if we believe that the trial court is correct, there is an emergency, the lease is James's authority for the landlord to enter.
Yes.
Okay.
If there's no emergency, yeah, or if there is an emergency, sorry, yes, she can do it. She can't then give permission to the police to help her out to go in. They were not helping with the emergency. They were useless in the emergency. They weren't there to help with the wiring or any of that. They were there because she was afraid for these reasons. And whether it's reasonable or not, that is not what the test is. And first, there is no case I could find that holds a landlord, because of a general lease provision like this, can let the police go in as an agent to, search and seize property. I do not believe that exists. But no, they cannot. She could go in if there's an emergency. And again, she had options. All this speculation about who knows what could have happened, that is not what can reasonably justify police action. You can't speculate about that. You have to go based on what the facts were that we found. And there just wasn't enough. She didn't have to go in. They really had waited almost 24 hours. She could have, nobody's really talked about this, she could have called James or called his brother to find out where it is. Lisha Reynolds testified they had their contact information. And in fact, they did actually show up there. So if that was the core of the problem, she had other options that were reasonable options, both to fix the apartment, but also to assuage her fear. But the Supreme Court has just held you cannot use the police this way.
Okay. Seeing no further questions, thank you so much. Again, well argued and well briefed. We will do our best to get a decision rendered as soon as we possibly can. Adjourn court, please.
All rise.